Imagine you're building a brand for nearly 40 years and you have a lot of home appliances products like ceiling fans or water heaters in electrical and electronic goods, and your company is having nearly 10 million customers. Now suddenly after 40 years, there is a big company which is a global giant trying to use the same brand name which you're using. When somebody is trying to copy your brand name, what we will do? We will file a case against them. This was a case between Marc Enterprises versus MARQ by Flipkart. The company which was running for 40 years is Marc Enterprises, and the big giant e-commerce company is none other than Flipkart. Flipkart was actually trying to copy this name and wanted the brand name so much that they went to High Court and Supreme Court, but in the end they lost the case. In this video, I am going to break down all of the details of these cases, and as an entrepreneur and brand owner, you should definitely listen to this case because it is a landmark case of trademark law. Come, let's discuss this case. Myself Rohini, your corporate lawyer from Lee Intelligentsia Private Limited. Now let's understand the story behind this legal battle. The company called Marc Enterprises was started in the year 1981 and they launched their brand in 1984 called MARC. And they had different line of products which is related to home appliances like ceiling fans, water heaters, geysers, etc. And they were also popularly called as kings of fan in the Asian market. Now, they were not just operating from 1980, they also had another company which was operated from 1961. So, it's a long-standing company. This company, Marc Enterprises, registered the brand name Marc under class 9 and 11 of trademark class in 1984 itself. They registered under class 9 and 11 in order to cover all the heating apparatus, cooling apparatus, electronic and electrical items which was connected to home appliances. Now let's fast forward to 2017. In 2017, the biggest e-commerce brand in India is Flipkart, and Flipkart is a giant which is being backed by Walmart in India. Now what Flipkart does is they try to launch their own home appliances products like TV, air conditioner and washing machine, and they are actually choosing a brand, and that brand name is called MARQ, Marc by Flipkart, in the year July 2017. In 2017, they are launching this brand and all the home appliances product were exclusively available only in Flipkart. Now what happened is Marc Enterprises saw that MARC and MARQ are phonetically similar and they filed a trademark case. Now comparing this legal battle with a story called David versus Goliath. We all know that David was a small, feeble man who was trying to fight a giant called Goliath. In the same way, Marc Enterprises was actually a small company compared to Flipkart, which is the biggest company. But even though Flipkart was the biggest company, how this legal battle they lost it, we need to find out. Before knowing what is the legal battle, I would like to tell you, if you are an entrepreneur who has newly started your business or have already started your business, we have a WhatsApp business community where we help all entrepreneurs to run their business without any legal hassles. If you want to join our community, there is a link in the description. Kindly click on the link and join our community today. Now let's come for the legal battle. The legal battle starts when Marc Enterprises file a case before the District Court of Patiala stating that Flipkart has infringed their brand name MARC and they are using as MARQ. So both are considered as Marc and MARQ, and also the line of products were so similar. What the lower court did is, they gave an interim injunction against Flipkart stating that they should not use the name MARQ. Flipkart could not accept this, so they went to Delhi High Court to vacate this injunction. Delhi High Court immediately did not remove this injunction. Instead, they took 8 years to listen both side arguments, and finally they gave a judgment in 2024 stating that both the names Marc and MARQ seems to be similar, so Flipkart cannot use the brand name MARQ. Flipkart again could not accept. They went to Supreme Court, and in the year Supreme Court upheld that lower court and the High Court have given a similar judgment, and we are also accepting the same view. So Flipkart was not allowed to use the name MARQ. After 8 years of battle, Flipkart actually lost the case. But the interesting fact is, we need to find out what was the argument given by Flipkart. There are 4 arguments which was importantly submitted by Flipkart company. The number 1 argument is the mark is visually and phonetically different. Flipkart stated that the spellings of MARC and MARQ are different and the pronunciation is also different. But court actually made an observation that whenever a consumer is walking into a shop and the customer is seeing these both brand names, they will actually get confused. So it is visually also similar, phonetically also similar, so they did not accept this argument. The number 2 argument was the Flipkart house mark removes the confusion. Flipkart actually stated that we are not going to use the mark MARQ separately. Instead, we are going to use along with Flipkart term. For example, mark by Flipkart. But in actuality, the court could find out that the term mark in the brand was visibly big, but whereas the Flipkart was very small in all of the products, so this could not be accepted as a house mark. Even your brand name should be unique and you cannot claim any confusions is not there because of house mark. So this argument was also not accepted. The third argument given by Flipkart was different customers and different products. Actually, the line of products were almost similar. They were also into cooling and heating apparatus like fan, water gases. But here the Flipkart was into TV, washing machine and air conditioner. But in total, if you consider, both are electrical and electronic items, both are home appliances and the line of customers are going to be the same. So this argument was also rejected. The final argument was that the Flipkart actually got the registration of MARQ before trademark registry. They claim that we have a registered trademark before the High Court. Though Flipkart has a registered brand name for MARQ mark, before they could get the registered status, in 2018 when they launched their brand itself, the court gave an interim injunction. Even if you have a registered brand name and court has an interim injunction, you cannot claim the rights on that. Now, from all the above judgments and all the above arguments, as an entrepreneur, we need to know the key principles of a trademark law. The first principle is, even if your brand name is phonetically similar with another brand name, that amounts to trademark infringement. Usually what happens is, if there is a visual similarity of logo and spelling, that is amounting to trademark infringement. But even if the sound similarity is there, then it amounts to phonetical trademark infringement. The number 2 principle which everybody should know is prior use versus corporate power. Even if you are a small company and you are using this brand name for a long period of time, and if a corporate power comes into play and they try to use the same brand name, they cannot win over the case. This has already happened in Burger King versus Burger King, where a small Pune outlet was using the term Burger King for a long period of time, and the huge Burger King from the American corporation, they could not win the case. In the same way, Marc Enterprises had a prior use and they could win over Flipkart, which was the biggest corporate power. The third principle which we should also be knowing is, whenever you are choosing a brand name which seems to be very common and similar, but you are trying to claim a uniqueness by adding your house mark, that is the company name, then also you cannot get the registration. For example, Flipkart stated that mark by Flipkart is what we are going to use it, but court did not accept that. Even your brand name has to be unique to get the registered status. But Supreme Court also gave a suggestion to Flipkart stating that they should change their brand, and also they stated that the stocks that they have in the name Mark, they can clear it out, but they cannot launch any new product or any new stocks in the name of Mark. So finally, as an entrepreneur, if you are going to launch your brand, what you should be doing is, you should make a thorough trademark search which will not end up in any legal problems in future. Second thing is, if you are using a brand name for a considerable period of time and someone else is copying your brand, you should immediately implement your right by filing a trademark infringement case. If you want to apply your trademark name without any legal hassles and also you want to file a trademark case, then call to this number and get your consultation today. As a legal observer, I want to ask you, where you are going to be a customer walking into a shop and seeing two brands, Marc and MARQ with MARC, MARQ, would you feel same or different? Kindly comment below in the comment box whether you will feel same or different. Like this, more useful video will be posted in our channel. Myself Rohini, your corporate lawyer from Lee Intelligentia Private Limited.